Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been to law school, you know that we are taught there in the hypothetical. And for those of you who attend my classes that I get to do around the state on the laws of self-defense in Washington State, you know that many people who come to my class engage in a game of one-upsmanship to see who can come up with the most ludicrous hypothetical to run by this guy. Well, today we're going to use a hypothetical that may ultimately, in the very near future, turn out to be not so hypothetical and actual reality instead. And it has a lot to do with a significant piece of legislation which is going to strip you, the lawful and responsible gun owner here in Washington State, of significant Second Amendment rights. But maybe something's going to happen between now and then. So let's spend a few minutes and talk about what if assault weapon bans are struck down before Jay Inslee gets to sign his into law? Okay, so the case I'm talking about today is the case of Miller v. Bonta. We have talked about Miller v. Bonta several times. Most recently, however, we talked about it in a series of 5 cases that were stacked up, all dealing with California's crazy gun laws, and how a clean sweep would really be a massive, not only gut punch, but really the knockout blow to gun control. Now, 2 of those cases we've already gotten rulings on, and they have both been positive. We did this video right here where we talked about Bolin v. Bonta, which was, again, the overturning of California's crazy handgun roster. Check that video out if you want to geek out about what a handgun roster is. Then we did this video right here about the case of South Bay Rod and Gun Club v. Bonta, also known as Miller v. Bonta, same Miller that we're going to be talking about here as well. And that had to do with overturning California's absolutely insane fee shifting law. Okay, now there are 3 cases left, the 2 here in Washington State that we're most interested in. One is Duncan v. Bonta because it deals with magazine bans. Wonder why we would be interested in that. And then the case we're talking about right now, which is Miller v. Bonta, because that is a challenge to California's assault weapon ban. Now, why does a ruling in the United States District Court for the Southern District of California in San Diego have anything to do with all the insanity going on here in Washington State? Well, you need to understand that all United States Court of Appeals are divided into circuits, and Washington State happens to reside in the 9th Circuit, as does the state of California. So theoretically, the precedence which is established within that circuit is binding upon the rest of that circuit. Now, what's being challenged in Miller v. Bonta is essentially 3 statutes. And for those in the hometown crowd here in Washington, I want you to pay careful attention because the language of these California statutes might be hauntingly familiar to a proposed piece of legislation kicking around in Washington State right now. Okay, now California uses Penal Code 30600 to define what is the unlawful act as it relates to assault weapons. And that statute, in summary, reads, any person who within this state manufactures or causes to be manufactured, distributes, transports, or imports into the state, keeps for sale or offers or exposes for sale, or who gives or lends any assault weapon or any 50 BMG rifle, except as provided by this chapter, is guilty of a felony. And you can see that, I'm sure the way this was sold to California residents is, it doesn't ban the possession, it only bans the commercial sale. Sound familiar? Now, how does California define assault weapon? Well, they actually use 2 separate statutes. I don't know the legislative history. I'm sure one of my California viewers will be able to tell me this, but it probably was that there was some legislation passed at one point, and then later on, more of it was piled on to expand the scope of this ban. California uses Penal Code 30510 to define assault weapons as follows. As used in this chapter, assault weapon means any of the following. And then, shockingly, it has this laundry list of firearms, which Washington, you can go ahead and compare this side by side with the list that's in House Bill 1240, and you will see striking similarities, okay? Is that where the California law stops? No, of course not, because then they also have California Penal Code 30515, which has kind of all the catch-all. And what I mean by catch-all is you generally describe a firearm and then you list a whole bunch of components, which you know it's likely to have, and say, hey, you know what, if it has any one of these components, well, then that also is defined as an assault weapon. What sorts of things, components and so forth, does the state of California ban under their statute? Well, it includes the following. A semi-automatic centerfire rifle that does not have a fixed magazine but has one of the following. A pistol grip that protrudes conspicuously beneath the action of the weapon. B, a thumb hole stock. C, a folding or telescoping stock. D, a grenade launcher or flare launcher. E, a flash suppressor. F, a forward pistol grip. 2, a semi-automatic centerfire rifle that has a fixed magazine with the capacity to accept more than 10 rounds. 3, a semi-automatic centerfire rifle that has an overall length of less than 30 inches. 4, a semi-automatic pistol that does not have a fixed magazine but has any one of the following. A, a threaded barrel. B, a second hand grip. C, a shroud that is attached. And I can go on because you will see, Washington, if you take a look at this statute, that's California Penal Code 30515, and then you compare verbatim the language that is in House Bill 1240, the exact legislation which is being proposed in Washington. This is the statutes that right now we are waiting for a ruling from this court at any moment. Now, it's not really just wild speculation that we believe that the Honorable Roger T. Benitez is going to rule in favor of the plaintiffs. It's pretty much well accepted. And you don't necessarily have to take it from me, because you could see what Governor Newsom has had to say on multiple occasions in anticipation of what we believe will be the forthcoming ruling. Now, here's where it gets interesting, Washington, you see, because Judge Benitez could issue a ruling anytime this coming week or at the latest probably next week. Now, House Bill 1240 is scheduled for executive session on March 28th. Now, it's going to go into executive session. We don't know how long it's going to stay there, but assuming it has its normal 1 to 2 day turnaround before it's either sent to a committee or rules are suspended and then it's sent back to the floor to be scheduled for a vote, we're still looking at a vote sometime in this week right here, the first week of April, which means the likelihood of Governor Inslee signing Washington's assault weapon ban into law before Judge Benitez actually makes his ruling is actually not particularly good. With the rapid fire that we have seen the first two opinions come out on, I believe that the smart money is that Judge Benitez is going to issue this ruling before the Washington State Senate has an opportunity to pass this House bill. And that's where it gets super interesting on two fronts. On the home front here in Washington State, it gets interesting because what would a responsible legislature do at this point? Would they perhaps tap the brakes and say, hey, maybe this thing needs to be resolved in the court system before we end up spending millions and millions of taxpayer dollars defending a piece of legislation that we kind of knew was dead on arrival already? Now, that's what a responsible state legislature would do. So smart money's probably not on that as well. Now, on the national level, on the federal and judicial level, here's where it gets interesting also, okay? Because Judge Benitez rules and Miller wins. Congratulations. With that ruling, Judge Benitez is going to likely issue a permanent injunction on the law, okay? Which means that's it, California. You don't get to enforce this law anymore. Any thoughts that people might have of California not appealing, come on, especially with an injunction going into effect usually within 14 to 21 days after, California is going to be forced to appeal this to the Ninth Circuit. This is where it gets real interesting. Now, if the Ninth Circuit wants to play some kind of a stall tactic, would they punt it to a 3-judge panel and see what happens there? And then if they do that, then they would end up appealing to the full Ninth Circuit panel again, exactly how they did in Duncan v. Bonta. It's possible, not highly probable. But here's the deal. When it gets to the Ninth Circuit, this is where the rubber meets the road, because at this point, the Ninth Circuit obviously wants to uphold the California assault weapon ban. They want to. The problem is they don't have the legal tools to do it anymore. They don't have the judicial reasoning. They don't have the case law. They don't have the legal analysis that's necessary to do it. The escape hatch, that two-part balancing test that they used for years and years and years to justify all these unconstitutional pieces of gun control legislation. Now, that's been completely welled shut now by the Bruin opinion. So if the Ninth Circuit follows the law and upholds Judge Benitez from the trial court level, that's the end of it. And assault weapon bans in the Ninth Circuit cease to exist. And if Washington's law has gone into effect, it ceases to exist at that moment. Now, this entire legal backdrop also is important for another reason, because if Governor Inslee were to sign this bill into law before Judge Benitez actually issued the ruling, or simultaneously or somewhere contemporaneous with it, the likelihood that you're going to get an injunction granted is exponentially increased, knowing that that ruling is out there. So that is the great what if. What if we have a ruling that undoubtedly states that assault weapon bans are unconstitutional? Does the Washington State Legislature proceed forward with a bill that they knew was unconstitutional from the beginning, and yet now will have been absolutely positively corroborated to be unconstitutional? That is where you are going to really see the agenda and the priorities of this particular legislature. Listen, you may have more questions about this or anything else related to what's left of our Second Amendment rights. If you do, you should know how to contact Washington Gun Law by now. But if you don't, hey, all of that is in the description box down below. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.